My dear student, today we are going to discuss about the contemporary theory of human rights. Introduction. Man is essentially to be free from any kind of bondage. The history of human civilization is the narratives of the oppressed people for its struggle for freedom. The classical social contract theory as well as Marxian theory testify it beyond reasonable doubt. John Locke's theory of social contract is one of the basic foundations for recognition of inherent, inalienable human rights and fundamental freedoms. The Holocaust of Second World War compelled man to redefine human rights and the fundamental freedoms of every human being in positive and pragmatic way for maintaining international peace and security effectively. The establishment of the United Nations marked the beginning of an era for respect for and observance of human rights and the fundamental freedoms of human beings by adopting various international human rights documents which are legally binding to the state parties. These documents include civil and political rights, socio-economic and cultural rights of individuals as well as collective rights of people which could be defined in terms of first, second and the third generation of human rights. Post-Second World War development. The establishment of the United Nations in 1945 laid the foundation for promotion and protection of human rights. The Charter of the United Nations places that the organization determined to reaffirm faith in fundamental human rights, in the dignity and the worth of human person, in the equal rights of men and women, and of the nation large and small. Article 1 of the Charter spells out 4 purposes which include achievement of international cooperation in solving international problems of an economic, social, cultural or humanitarian character, and in promoting and encouraging respect for human rights and for fundamental freedoms for all without distinction as to race, sex, language or religion. The Charter contains 7 specific provisions for promotion and protection of human rights and fundamental freedoms. Article 1, Article 13, Clause 1, Subclause B, Article 55, Article 56, Article 62, Clause 2, Article 68, and Article 76, Clause C are the foundational provisions for the promotion and protection of human rights under the Charter of the United Nations. The Charter universalized the concept of human rights, which was introduced in some countries hundreds of years ago. It is the first international document which recognized the respect for human rights and the fundamental freedoms as a principle of international law. It is well known that the UN Charter is a global constitution in which it neither defines human rights nor enumerates lists of human rights. However, these provisions have not only served as the basis for the United Nations action in the field of human rights, but also constituted, together with the provisions of the Universal Declaration of Human Rights 1948, as the source of many human rights instruments for both global and regional bodies. The Universal Declaration of Human Rights was adopted in 1948 and the twin international covenants were adopted in 1966. which codified the two sets of rights outlined in the Universal Declaration of Human Rights. International Covenant on Economic, Social and Cultural Rights entered into 1976. Later, the General Assembly also adopted two optional protocols to ICCPR. The first optional protocol to ICCPR 1966 and the second optional protocol to ICCPR aiming at abolition of death penalty. Recently, one optional protocol to International Covenant on Economic, Social and Cultural Rights was also adopted in 2008. However, the protocol has not come into force till date. The two international covenants, together with the Universal Declaration of Human Rights and the optional protocols, comprises of the International Bill of Rights. The fundamental rights and freedoms contained in the Bill of Rights have been further elaborated by dozens of human rights treaties. First generation of human rights. The origin of human rights is traced back to ancient Greek. Later, it was developed through various phases like Glorious Revolution, French Revolution, and the American War of Independence, among others. The various rights contained in the Covenant on Civil and Political Rights are not the new rights. These rights are the right that had been developed gradually during the long period of times since the time of Greek city-state, and it began to concretize them in Magna Carta, the American Declaration of Independence, and the French Declaration of the Rights of Man and Citizen. These rights reflect human values, and as such, they are incorporated into national constitutions of various states as well as regional conventions and international documents. Since these rights are incorporated in different international and national documents, they represent an overwhelming consensus of international community, giving rise to the rules of international customary law of general application. Therefore, the global community has met the realization of civil and political rights as the first generation of human rights. The civil and political rights, as outlined in the Universal Declaration of Human Rights, that means UDHR, are enumerated in the ICCPR, which contains 53 articles. Article 4 of the ICCPR stipulates 7 non-derogable rights, which state party cannot derogate even during national emergency. The core 7 provisions of the ICCPR are: number 1, right to life; number 2, right not to be subjected to torture; number 3, right not to be held in slavery or servitude; 4th, right not to be imprisoned on the ground of inability to fulfill a contractual obligation; number 5, right not to be held guilty in retroactive application of criminal law, ex post facto law; number 6, right to be recognized as a person before law; number 7, right to freedom of thought, conscience and religion. Second generation of human rights. American and French Revolution are considered as the main sources and the origin of civil and political rights, whereas economic, social and cultural rights are considered to be originated from Russian Revolution of 1917 and the Paris Peace Conference of 1919. The significance of Paris Peace Conference led to the establishment of International Labour Organization, which emphasized on the concept of social justice. In this regard, the International Labour Organization has been successful in developing many international standards in the form of conventions and recommendations, coupled with effective system of supervision and investigation of complaints. The primary objective of adopting ICCPR and International Covenant on Economic, Social and Cultural Rights in 1966 is to expand upon and give effect to the Universal Declaration of Human Rights. Once the Commission on Human Rights began to consider the drafting of a Covenant on Human Rights in 1949, it was confronted with proposals put forward by Soviet Union and Australia, which brought to extend the scope of the covenant for inclusion of economic and social rights as well as civil rights. French delegates expressed a desire to see economic and social rights included, but in a separate and later covenant. The Commission adopted a resolution and requested the Secretary General of the United Nations to prepare a report on the activities of other bodies of the United Nations as well as of the specialized agencies affecting matter within the scope of Articles 22 to 27 of Universal Declaration of Human Rights (UDSR). Later, the Commission decided that the draft covenant covering certain essential civil rights should be the first series of the covenant and that it would consider additional covenants dealing with economic, social, cultural, political and other categories of human rights at the subsequent sessions. The developing countries of Asia, Africa and Latin America and even USSR and East European countries were in favor of inclusion of both economic and social rights. Finally, the Commission adopted two international covenants on human rights, including measures of implementation, namely one on economic, social and cultural rights, other on civil and political rights. The International Covenant on Economic, Social and Cultural Rights 1966 comprises of a preamble and 31 articles, which are considered to be the second generation of human rights. The Covenant includes the following rights. Number 1, right to work. Number 2, right to education. Number 3, right to health. Number 4, right to adequate food. Number 5, right to culture. Number 6, right to enjoyment of just and favorable condition of work. Number 7, right to form and join trade union. Number 8, right to social security. Number 9, right to family and protection of motherhood and childhood. And number 10, right to adequate standard of living. Third generation of human rights. The third generation of human rights refer to the fraternity or brotherhood. This category of rights is based on the sense of solidarity. The effective exercise of collective rights is a precondition to the exercise of other rights. The most serious rights belong to the third category of human rights are right of self-determination and right to development. Right of self-determination. The International Covenant on Civil and Political Rights 1966 and the International Covenant on Economic, Social and Cultural Rights 1966 not only affirmed the right of all peoples to self-determination but also imposed an obligation on a state to promote the realization of right of self-determination and to respect the right. Article 1, Para 1 of both covenants stipulates that all peoples have the right of self-determination. By virtue of such right, they freely determine their political status and freely pursue their economic, social and cultural development. The right of self-determination is also recognized in a number of multilateral and bilateral treaties. The Helsinki Final Agreement and the Protocol additional to the Geneva Conventions 1949 also recognize right of self-determination. The principle of self-determination was also recognized as the basis of settlement of a number of disputes, namely the Kashmir Dispute 1947 to 1958, the West Iranian Question 1949 to 1962, the settlement of Sar Question 1955 and the Algerian Question 1960. Right to development. The right to development as a human right has been the subject of extensive reflection and formulation for nearly 3 decades and is now on its way to acquire the status of an internationally recognized human rights. Keba M. Bai, the President of the Supreme Court of Senegal, emphasized that all fundamental rights and freedoms are necessarily linked to right to existence, to higher living standard, and therefore to development. A few years later, Karel Bassat classified the right to development as a human right of third generation. Subsequently, the UN General Assembly adopted the Declaration on Right to Development on 4 December 1986 with overwhelming support of majority governments. Article 1 of the Declaration stipulates that the right to development is an inalienable human right by virtue of which every human person and all people are entitled to participate in, contribute to, and enjoy economic, social, cultural, and political development in which all human rights and fundamental freedom can fully be realized. The article further provides that the right to development also implies the full realization of the right of people to self-determination. The right to environment, the right of the indigenous people, and the right of the minority are also included in the category of third generation of human rights. The right to development is of multidimensional characters, incorporating all civil, political, economic, social, and cultural rights, which are necessary for promotion, protection, and development of individual rights and freedoms. Conclusion. Magna Carta, Petition of Rights, French Revolution, American Revolution, and the October Revolution laid the foundation for promotion and protection of human rights in the globe. The establishment of the United Nations after the end of the Second World War not only expedited the movement for promotion and protection of human rights, but also helped in realization of these rights by adopting legally binding international human rights document and the non-binding declarations. The classification of human rights into three generations does not mean that human rights are not interdependent. Actually, human rights are interdependent, indivisible, and inherent in their nature. The full realization of civil and political rights without the progressive realization of those second and third generation of human rights is impossible.